Thank you very much.
So it's a pleasure to have you both back in the studio, and you want to continue something you started some time ago, talking about rights of tenants and landlords in a tenancy relationship. Yeah?
Exactly.
Yes.
Okay. I cannot remember exactly where we stopped, but I know that we tried to talk about so many of these rights that tenants and landlords both have.
Yeah.
Okay, but for where we're going to continue today will be from talking about quit notice. Okay, so when is the most appropriate time to serve a quit notice to on a tenant?
Thank you very much, Ruth. Like you said earlier, we actually discussed lots about the rights of a tenant and landlord the last time we had this discussion on this platform. And then why this question is actually very important is because we see situations where tenants are complaining that the landlord either did not serve a quit notice on me before asking me to leave the property, or did not follow the particular procedure stated in the laws regulating tenancy relationship with respect to the service of quit notice. But specifically, the law has actually made provision for the timing for the service of quit notice, like the law regulating tenancy relationship in Abuja, which is the Recovery of Premises Act, stated specifically in this section 9. However, that there is no particular time for the service of a quit notice, but that it must be served within the period of the subsisting tenancy relationship. And it will be an invalid quit notice where it is served, where the time that is left in the tenancy, existing tenancy relationship is not enough time to cover for the period that the quit notice is supposed to last. Assuming if
are you trying to explain that?
Okay.
So I think it would be right if you explain what that means.
Exactly. Now, if I am a yearly tenant, and the law already made provision in Section 8 of the Recovery of Premises Act that I'm entitled to the service of 6-month notice, which is half a year's notice, before I can the landlord can proceed in evicting me from the property. Now, if, for instance, I am already 8 months into my tenancy relationship with the landlord as a yearly tenant, and the landlord comes up to serve me a quit notice at that point, now the time that is left is no longer up to 6 months, because the provision of the law says that the quit notice should ordinarily expire a day before the end of the tenancy relationship.
Okay.
So I can even decide as a landlord to serve you quit notice from the beginning of the tenancy relationship, but as long as it is up to 6 months and it does not go outside of the tenancy relationship. That's the provision of the law as stated in Section 9 of the Recovery of Premises Act. But of course, like we said the other day, there are situations where the landlord actually need not serve quit notice on the tenant, and most of the time, what I actually stated that why this question is very important is because I have a situation like I had a situation like that a few days ago, where a property I managed for one of my clients, we served quit notice, 6-month quit notice on them, and it was supposed to expire last month, which of course already expired, and the tenancy relationship are terminated. Then upon proceeding to see how we can ask them, come on, what are you still doing on the property? The tenant came up and was like, no, that my tenancy just expired. You are supposed to give me a period of time for me to stay, I
actually wanted to ask from the beginning to ask you that how many tenants even know about these things, so that they would even challenge a landlord and say, oh, you're supposed to give me by this time, or you would have, or you should not at all. So, but from what this tenant is saying, it means the person does not even know anything about it.
And most of the time, that's what happens in tenancy relationship. Most of the time, and like I said on the last time, it is always very important you engage the service of a lawyer to help you either interpret the tenancy agreement before signing to it, because like we said on the last time, landlords can come up with a particular clause waiving a waiver clause saying that I'm not going to serve you a quit notice upon the expiration of this tenancy, that the tenancy will expire naturally the moment it comes to an end. Okay. And there are of course other situations, like we said on the last day, that where there's a fundamental breach. Assuming I give, as a landlord, I give you my property which is a residential for residential use, and the title that I have from the government is for residential purpose, and all of a sudden you start using it for commercial purpose. At that point, the authority that give me this allocation can come back to revoke it because I'm using it for a different purpose. So when situations like that come up, you are not expected to for the landlord to serve you a quit notice. He can just terminate the tenancy relationship because it's already going to affect his title to that particular property.
Interesting. Do you want to add anything?
Well, he has said it all.
Okay. Yeah. So now, does the tenant have any constitutional human rights in this tenancy relationship?
Well, yes. The tenant has constitutionally, according to Section 36 of the 1999 Constitution, he has the right to fair hearing. But then that's like at the determination of the tenancy relationship, where the landlord wants to kick him out or does something that is unlawful. The tenant has the right to go to court for the court to hear his own side of the story, you know, rather than just telling him to leave like that without serving quit notice, without serving the 7 days notice to recover possession. So yeah, he has his constitutional right.
Okay, so at what point now can this serving of a quit notice be, will I say, illegal or not in accordance with what is the provision available? If
it's stated in the tenancy agreement, and the tenancy agreement says 3 months for a yearly tenant, and he serves the quit notice 3 months after the expiration of the tenancy agreement, it's illegal. Yeah, except it is stated in the agreement that he can serve the 3 months quit notice at any time. And then where he doesn't serve quit notice and he decides to just tell the tenant to leave, and maybe he calls hoodlums, like guys in the area, to throw him out, or he locks the tenant's door. Yes, they do. They just lock it up, and you go to work, you come back and meet your house locked up, and you can take the landlord to court even when your rent has expired. Oh, yes.
Okay, yeah, because I wanted to ask, because sometimes maybe some of these landlords will resort to that if they have served this quit notice and the tenant has refused to leave the house, you know, and then they may just get upset and like, well, let me just show him that I am actually the owner of this house.
The last time we came, my colleague said that when a tenant's rent expires, the tenant becomes a statutory tenant. He is no longer the tenant of the landlord because the agreement has come to an end. Now only the law can throw him out of the premises. So the landlord has to go to court. Whatever the court orders is what they should go with. So the courts can give an order, like telling the tenant to leave within maybe 2 months, 3 months, he should get a place. Now, where he doesn't leave, the courts can, appoint, maybe order the police to take him out. But then the landlord shouldn't do it on his own, because it would lead to, like, you're disobeying the order of the court. Yes, which is a contempt of court.
Okay.
Very, very, very fundamental. Like she stated, one of the rights of a tenant in every tenancy relationship is his right to fair hearing. You know, most of the time, why I will need to add this, because there are situations where most of these kind of practices are done in Lagos State, where a landlord will proceed to court in a bid to evict a particular tenant, and then come up with a fake person who will act as the tenant in court.
Okay.
And then the court will make an order, assuming that this is the tenant in question. And of course, where a court has made an order, that same court does not have the power. The law will tell you that the court is functus official. It doesn't have the same power to go back to undo, except you have to proceed on appeal.
So even if you say, well, I wasn't the tenant that was there.
Now, this is where you now go ahead to enforce your fundamental human right. That, I wasn't heard. The provision of the law, going by the Latin magazine, audio authorem patem, it says you must hear the both parties in the determination of his civil rights and liabilities. the both of them must be heard. You don't just hear one party and give judgment. No matter what, he has some. Even if you feel he doesn't have anything in his defense, allow him to be heard. And you must make adequate provision for this to be done. And the laws regulating recovery of premises actually made provision that you must actually serve on him all of the processes, court processes leading to this recovery of premises. Now, if you are before the magistrate court and you are serving a plaint on him, ensure that you serve it on him personally. It's only where it's been established that you cannot effect personal service on him that you will now carry out a subsidiary service by pasting the process at a very conspicuous position on the premises where you are seeking to recover. So all of these processes must be in place to enable him come defend his position, because I could come and tell you, okay, well, I agree that I am owing this person, or you have served me quit notice, but we had an agreement. I effected such and such repairs. Please, the court can make an order for the refund, because where there's a stated agreement that go ahead and repair as a tenant, upon eviction or termination of this tenancy relationship, I will refund back to you. He can put up such a defense and get back his money. So the right to fair hearing is very, very, very fundamental.
Interesting. We'll continue the conversation after this break. Do stay with us.
One Radio.
Welcome on board to the Human Rights Radio.
Redefining broadcasting.
This is to inform the general public that the activities of scavengers, also known as Babambola, is prohibited within the Federal Capital City. Their activities are henceforth restricted to the area councils. Residents of the Federal Capital City are advised to be vigilant and report any suspicious activities to law enforcement agencies. Together, we can make Abuja the city of our dreams.
èyí ni láti kéde pé ojúṣe àwọn ìṣàgolo sapáànù tí a mọ̀ sí Babambola ti dókun nílùú Àbújá àti ìjọba àbílẹ̀ mẹ́fẹ̀ẹ̀fà bí ọwọ́ sìnkú àwọn agbófinró bá wá bá ẹnikẹ́ni nínú wọn yóò fi ojú ba ilé ẹjọ́ o. ẹ̀yin olùgbé Àbújá ẹ yára tètè tẹ́tí lẹ́kọ̀ọ́ tẹ́ bá rí ẹnikẹ́ni tí ń yọ́lẹ̀ ẹ̀dà tí kò tẹ̀lé òfin tó sì ń ṣàgolo tí ń sapáànù ẹ tètè fi tó àwọn agbófinró létí. àjọṣe wa ni o láti mú kí olú ìlú yìí dùn ún wò kí ó sì dùn gbé pẹ̀lú ìrọ̀rùn. ìkéde yìí wá láti iléeṣẹ́ ìjọba olú ìlú yìí ìyẹn Federal Capital Territory Administration.
Awidna akugna aza vien kinzin nege tuntun aza mbatun aya una vidankulu na kobege Babambola atela jebaje o kinzin ne nkoyin tinya kola ka hae abatun kola pojin unara kansi vien ba logutna e kinzin ne ozana wa sasatu vidankulu wotna aba wa api aga otata agna kinzin dalo mbasaselo ge balaweka na zaipia da na azalaba saselo kinzinege balawepi na ja zaipia bakara na bana banwa ba tabashiba agaba tata yutna wode ya mi kinzine ko na ba abwa abeji awudne ba gbin new city atutun jina pokoge Federal Capital Territory Administration.
udu mmiri ebidola a na-adọ ọhaneze aka na ntị ka ha gbochie ma kwụsị akparamagwa ga-ebute mmiri ọdụdọ na mbuze dịka iwufu ahịhịa n'ime mmiri na-asọ asọ ya na ịtụnye ihe n'ime gota. a na-emekwa ka ị mara na iwu ụlọ n'ebe na-ekwesịghị dịka ụzọ mmiri nwere ike ịkpata ịtụfu ndụ ndị mmadụ n'efu ya na ihe nweta ndị mmadụ ịla n'iyi ma ihe kwesịrị dị mma. ọ bụ Federal Capital Territory Administration FCTA na-ezitara gị ozi a.
A yayin da
damuna ta fara kankama, an shawarci al'umma da su guji bata muhalli wanda ke iya jawo ambaliya. Zub da shara ba kan gado shine makasudin babbar ambaliya a birnin tarayya Abuja. Saboda haka kar ku zub da sharar ku a magudanan ruwa. Bugu da ƙari an shawarci al'umma da su kiyaye yin gine-ginen gidaje a hanyoyin ruwa wanda yin haka kan iya jawo rusan da zai laƙume rayukan al'umma da dukiyoyinsu a lokacin damuna. A koda yaushe ku kasance mai yin abin da yake daidai. Wannan sako na zo muku ne daga hukumar birnin tarayya FCTA.
Wani ya samu wani yana hauka, mu mun yi nasara.
Gẹ́gẹ́ bí a ti mọ̀ wípé àsìkò òjò la wà, èyí ni láti sọ fún gbogbo ènìyàn láti yàgò fún ìwà ìdọ̀tí, dídà ìdọ̀tí síbi tí ò bójúmu tí ó lè fa omíyalé, àgbàrá ya ṣọ́ọ̀bù, dídà ìdọ̀tí síbi tí ò bójúmu tàbí òpópónà sì jẹ́ ohun kan gbòógì tí ó ń ṣokùnfà omíyalé, àgbàrá ya ṣọ́ọ̀bù ní ìlú Àbújá. Ẹ má ṣe da ìdọ̀tí sínú gọ́tà tàbí ọ̀nà tí ìjọba ti pèsè sílẹ̀ fún omi láti gbà kọjá. A tún fi àsìkò yìí sọ fún gbogbo olùgbé FCT Àbújá láti rí dájú wípé wọn ò kọ́ ilé sí ọ̀nà tí omi ń gbà kọjá. Èyí lè ṣe okùnfà pípàdánù ọ̀gọ̀rọ̀ ẹ̀mí tàbí pípàdánù ohun ìní ní àsìkò òjò. Ẹ ṣe ohun tó tọ́. Ìkéde yìí wá láti àjọ FCTA Federal Capital Territory Administration.
As the rainy season begins, the general public is hereby advised to avoid environmental practices that could cause flooding. Indiscriminate waste disposal has remained a major factor causing flooding in the FCT. Do not throw your garbage into gutters and drainages along waterways. Residents are also advised to avoid building houses around natural waterways, as this could also lead to loss of lives and property during the rainy season.
Do the right thing. This message is from the Federal Capital Territory, FCTA.
Making the world a better place every day. Human Rights Radio 101.1, redefining broadcasting.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Pro Bono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
Thank you for staying with us. 10:25 a.m. On Pro Bono Chambers this morning, I have been speaking with Barrister Peter Oche and Barrister Maureen Itoha from Pilarest Attorneys. We're looking at the rights of a tenant and landlord. That is right of tenants and landlords in a tenancy relationship. Now, we've spoken to some extent about what rights the tenant does have. Let's listen to the ones the landlords have.
Okay, thank you very much, Ruth. You see, most of the time, most of the laws that we have regulating tenancy relationship are actually pro-tenant, and we seem to forget that there is another party in this relationship who is the landlord that also have rights that should be protected. You know, where we don't have a balanced situation, we're going to actually always have a problem in the tenancy, every tenancy relationship. Now, one of the basic rights of a landlord in every tenancy relationship is his right to rent review. He has a right to either review his rent, the rent for the rent for a particular property, either upward or downwards. And of course, we know most of the time in our climb here, we always have issues of upward rent review.
Yeah, exactly. It never comes down.
You know, there are a lot of reasons why a landlord will actually want to review the rent. And now, not minding the dilapidating nature of the property or the wear and tear, they keep increasing this rent. Now, economic policies and government policies most of the time push them to the wall. Even though there are situations where the law puts up machineries for rent control. Now, we don't have that sort of enforcement in our tenancy laws in this country as such. But then there's a particular clause that is referred to as the rent review clause that should be inserted in every tenancy relationship, and the tenant must insist that that particular rent review clause is inserted. Now, this rent, what was it all about? It puts a ceiling on the a level of percentage that the landlord cannot go beyond. Now I can decide to say, okay, within this period of time, in the clause now, I can decide to say within this period of time, as a landlord, you must not increase the rent above this particular percentage. It will actually go a long way to control tenancy relationship and then arbitrary increments in rent as we have it presently in the urban areas, especially in Abuja. So it's one of his rights, rent review, but then the rent review clause must always be inserted in every tenancy agreement to regulate these particular rights of the landlord.
So, should there be any form of or any kind of reforms to be done on the tenancy laws?
A lot. And at this point, I would like to sincerely commend the government of Lagos State. In the Lagos State tenancy laws, there are actually lots. Lagos State tenancy law 2011. There've been lots of introduction of new terms into the law that actually has brought certain level of sanity into tenancy relationship in the Lagos State. Now, particularly section 4 of the Lagos State tenancy laws 2011 provides that no landlord or agent of the landlord is allowed to receive rent in excess of 6 months for a monthly tenant or in excess of 1 year for a yearly tenant. And there's actually a penalty for this, 100,000 naira or 3 months imprisonment. And the law also went on in the same section 4, the other subsections, to state that no prospective or sitting tenant is permitted or allowed, that it is unlawful for a sitting or prospective tenant to offer rent in excess of 6 months for a monthly tenancy or rent in excess of 1 year for a yearly tenancy. And there's also a punishment for that too.
Okay, you're talking about, for instance, those that will tell you pay
more than
two years or for a yearly.
Yes, well, what's situation like that in Abuja? They'll tell you, some of them will tell you, we want to actually recoup what we have spent in putting up this structure. So pay more than 1 year.
Okay.
The Lagos State tenancy laws prohibit such practice.
Wow.
But it's actually unfortunate that we don't have that in the recovery of premises laws of Abuja, which is one of the law regulating tenancy relationship in the FCT. But I think it's worthy of emulation. We can actually import the same thing and then make it of a universal application to all the states of the federation.
So I really wonder why it is that it looks like Lagos is just always upwardly moving and other states are lagging behind. Yeah, so why is that?
Well, I think it's because of the nature of generally the state is progressive.
And no other state would envy that in a good way to want to.
Well, some do, but it's just that they're always ahead. And then the Lagos State tenancy law went on to say, because of course there are situations where apart from your rent, the law makes provision for the payment of other forms of service charge and also security deposit. Now, section 5 of the Lagos State tenancy law makes provision for that. Now, but then went on to state that where you are paying for a service charge, there must be a separate issuance of receipt for that particular payment. And then the landlord must give you 6 monthly update on expenses of that particular
this is interesting. This one you're saying now is applicable in
Lagos State.
Not here.
It's not in our laws here. So these are some of the reforms that have been introduced, and they're talking about a security deposit. Security deposit is actually a practice that it's already everywhere in the Western world, where apart from your tenants, your rent, you upon signing into the tenancy relationship, you have to advance a particular amount of money, sometimes about same amount with your rent, should there's any damage done on the property at the cost of your stay. If you are moving, because we have situations where a tenant, after destroying properties, will just move out of the property even without the knowledge
sneak out like
of
a thief
the landlord. Do you understand now? But where because we're also talking about protecting the rights of the landlord as well. I should have, if I have an investment, I should also make profit from it. So in such situation, the landlord can decide to say, okay, fine, you have gone, but I have a security deposit that can make up for, because we actually have some very, very wicked tenants that could just feel that the landlord is making too much money, let's proceed and destroy and damage stuff after I didn't have a good relationship with him. You know, in situation like that, security deposit will cover for it. And even in the
so, but what if you didn't create any damage? Nothing happened to the property.
The money will be refunded. Yes,
it should be refunded back to you. Usually within 21 days. In other climes, other jurisdiction. Now, it's also very important. We've been talking about the service of quit notice, which should flow from the landlord to the tenant. How about the service of quit notice that should flow from the tenant to the landlord?
You want to quit?
No, yes, I want to leave. Do you know, of course, none of our laws in Nigeria here with respect to tenancy relationship has countenanced this position. But we have laws like that, like in California, USA. It's part of it's included in their tenancy law, where you must give, the landlord is entitled to give you 3 months notice to quit for a monthly tenancy, and you are also required to give 3 months notice to quit for a monthly tenancy. Now, this is because I could have a projection that this is what I want to achieve with this relationship within a particular period of time, and then all of a sudden you wake up one morning and say you are terminating the relationship. It's going to affect my investment, it's going to affect my projections for the year. So how about you telling me ahead of time? It also gives me the opportunity to be able to go ahead and probably rally around to see if I can get another tenant, or put it up for other tenants to come and actually apply for it. You understand? So I think it should be a two-way thing.
Well, okay, is that obtainable now in
our laws? No, it's not. It's not.
Because I'm thinking too, the tenant may want their privacy, because I've seen a situation whereby someone tells you about a house and like, hey, but someone is still there, and so you want to see what is there, even if they tell you, well, he's going to move out in the next 1 month. You are tempted to go and check the place out, and the person's things are still there, they're still living there, so it's like an intrusion. They're intruding in their, in their privacy and stuff like that.
Now,
so
yes, it is right. Exclusive possession to the premises is right. But let us not forget that this exclusive possession does not outrightly put out the landlord from inspecting his property once in every while. It is very important. But of course, this is subject to the consent of the.
Yes, this goes beyond the landlord. Now he is bringing people.
Okay.
To come and check the place out, because he would be scouting out for tenants, and he tells this person, and the person says, well, I would come. I have had to go see a place one time like this. The only place we didn't enter the bedroom and the bathroom. So, and how would you even take a place like that if you've not seen every single place? And how can you also see every single place when there are things around? So just how feasible is that?
I don't think it's now in situations like that. If we have such situation in our laws or countenance in our laws, it's very simple. You give the tenant a prior notice and give him your notice should contain the nature of inspection you want to carry out.
Okay.
Yes, and of course he should be present, because you can't do that in his absence. He will be present and then probably take you around to ensure that his properties are also protected, in as much as he's also giving you the limited right to inspect your own property. So I think the law can actually make provisions that will protect both parties if we countenance such situations in our tenancy laws.
Interesting. Well, let's open the phone line at this point and see if we can get a few calls in. 081-8999-1011. If you've been following the conversation, you may have a question or two. So call the number 081-8999-1011 to ask those questions right now. Or if your questions are totally about different legal matters, still call in and the barristers will be glad to answer your question. 081-8999-1011. Hello.
Good morning.
Good morning.
My name is Joseph Kennedy calling from Guagua.
I didn't get your name.
Kennedy Johnson.
Kennedy.
Yeah.
Okay, please go ahead.
Okay. There is one lady that bought a house close to my house this last month. But there is a tenant living on the property. From 2 days ago, the lady came to tell the woman that her whole house has expired and that she wants to pack in. The woman told her that unless the next month before she will back out of the house. So I don't know what the guy will do, because if the house that she is living in has expired. So that's why I said let me ask so that I will know what to.
Okay, let me understand it. The person currently living in the house, the rent has expired.
Yes.
Then the other woman bought that particular house.
Yes.
From the initial owner.
Yes.
Okay, so.
So that's why I said let me.
The truth is, it doesn't matter if there's been a change in the ownership of the property where the tenant is occupying. The law with respect to the chronological process that should be followed in evicting a tenant must be followed and must be complied with. Now, of course, we have situations where landlords go ahead to sell their properties whilst the tenancy relationship between them and the tenants are still subsisting. Now, if I am a new landlord or the new owner of the property, all I need to do is to give them a particular notice that okay, ownership of this property have changed, and then I'm about to take over complete and absolute possession of my property. But it doesn't stop him from following the procedures. He must, where need be, serve quick notice as should be done. Go ahead and serve the 7 days owner's intention to recover possession before proceeding to either the magistrate court or the high court. So the same procedure still applies to him, because like we say on the last day with respect to this particular discussion, we said upon signing to the tenancy agreement, the tenant acquires both legal and equitable rights to that particular premises, and the law also bestow upon him exclusive possession against all third parties, including even the landlord, but with some limited exceptions.
Now, does the former landlord have any role to play in this? The transition period or the transition process, is the tenant supposed to be, told about the new landlord? Perhaps the old or initial landlord should come and say, okay, ownership has gone to this person and you should, because I don't know how involved he is, even though his call dropped, so I wouldn't know how close he is to the situation for us to know whether or not the tenant has been told about this before, or to what extent the notice she's being given, because the new owner now wants to move in, but she's saying after the next 1 month.
Just like you said, I think the information should flow both from the old tenant or the outgoing tenant and the incoming tenant, the landlord, sorry.
Okay.
Now, I should inform you that, okay, look, you're my tenant, your rent is still subsisting. And then not just inform the tenant, but I should also go ahead to inform the prospective landlord who is coming in to take over the management of that property that, look, if possible, hand over the tenancy agreements to him, this existing tenancy agreement.
Okay.
Go through this. This person's rent is still subsisting, it's not expired yet. This one will expire by so time. If it expires, if the person refuses to move out, follow the legal and statutory procedure to evict the particular tenant. So I think there should be a proper communication between both parties and even the third party, that is the new landlord now. It's where we don't have a proper communication between them that there's going to be conflict.
Okay. All right, 081-8999-1011. That's the number to call. You can call in. It's Probono Chambers on Human Rights Radio. Hello.
Good morning.
Good morning. Welcome.
Yeah, I paid for a rentage for 1 year.
What's your name, please?
My name is Mr. Daniel from Lackham.
Okay.
Or rather, I sublet my property to somebody and he paid for 1 year. And I am living in another person's apartment. So the person has given me a quick notice. And I want to go.
Hello? Mr. Daniel, I can't hear you.
I'm saying, I am living in somebody's apartment, and I have my property somewhere, which I have rented it out to somebody, and he paid me for a year. But he has not used the money he paid for the period of 1 year.
Okay. Mr. Daniel, your connection is really poor. Perhaps you should call back.
All right.
Sorry about that. I do hope you call right back so we can get the full story. 081-8999-1011. Probono Chambers on Human Rights Radio 101.1 FM. Let's have you call in and share your questions with us. Hello?
Hello?
Good morning.
Good morning.
You need to turn off your radio, please.
Yeah, I've done that.
What's your name?
My name is Ngozi.
Okay, we're listening.
Yes, I called sometime last month on, and I made the complaint on my landlord that I have a leaking roof. He will always come and collect the money when the rent is expired, and he will not repair the roof. And after then, he won't pick my calls again. So, first of this month, the rent expired, and he sent me a text. So I told him to come and repair the roof. But he has been particular about the money. Now, a sister of mine said that I should just leave the house. But the thing is that I've not gotten a place because I didn't have that in mind to leave the place initially. And I can't just wake up one day and get the house. So I have to look around. Now, am I supposed to pay him, or should I just tell him that, okay, you should give me some time to get another place? The couple of months or weeks that I'm going to stay, am I supposed to pay for it?
Okay.
Okay, it's actually very simple. Just like she said, one of the rights that is available to her as it is right now is to terminate the tenancy relationship, because the provision of the law is very simple. Where there's a fundamental breach of any of the terms, whether implied or express terms of the contract, and we know that peaceful enjoyment of a property is one of the implied terms of every tenancy relationship, whether stated or not. And this is already in breach, and this is a fundamental term of this relationship. Any of the party where there's a breach of a fundamental term of the tenancy relationship can actually withdraw from a tenancy relationship. Now, it's so unfortunate that there are a lot of situations that have not been countenanced in our tenancy laws, but like in the United States, I think particularly is it Washington laws, tenancy laws, actually has a provision that permits the tenant to withhold the rent where there's a breach on the part of the landlord, such as maybe he's supposed to fix a particular thing on the property and he's not doing it. I reserve the right as a tenant sitting on that particular property to withhold the rent up until that particular repair is carried out. But I can't tell you that that is the legal position as it is right now in our jurisdiction here in Nigeria. But a very simple option that is just like she said is terminate the tenancy relationship, go get another place and move, because that's actually a fundamental breach of every tenancy relationship. And if you can come into an agreement with the landlord to say, okay, I have some monies to repair this particular defect on this property, put it expressly on the document to say that, okay,
I think the barrister that was here that I can't remember who was it, barrister Uche or some other guest. I think she was advised to either to try that or to move out.
I think she should sign an agreement with the landlord. Since she has her rent, use from the rent money, fix the leaking roof, and then give the balance to the landlord, since the landlord doesn't want to fix it by himself. And then where he refuses is either she moves out or she maybe take the matter to court for the court to order specific performance on the part of the landlord.
Must she live in that house? She should move out.
Exactly.
She doesn't sound like someone who wants to live in that house.
You know,
I'm sure there's something she's enjoying from that.
I think she's like me. I hate to move. I don't like moving out, packing, and you know the stress of going when you have settled somewhere.
Yeah.
So I think she should take him to court.
But she's been there for some time, and that has been his body language. From what she explained to us that day, though.
It's because she's really interested in the property. That's why he has the power to do what he's doing.
Okay, well, Ngozi, you've heard the barrister. So but what she's also asking is, now that she is just trying to see if she can get another place. The thought just it came to her, based on what her sister suggested. But then it's obviously she may have to spend a few more weeks or maybe even a month or so before she gets another place. This period now, should she pay for it?
I think it still boils down to the proper communication between
the landlord will be upset. The landlord will just be upset at this point. I'm sure he would want money.
But then the landlord cannot kick her out of the house just like that. He has to go to court.
Okay. So while he's going to court and she should just keep looking for her house before he comes back from the court, she'll get a place and move.
But let's not forget that the landlord can, even if she moves out of the property,
he will
landlord
still
can
get
proceed against her to recover for the period that she has
she would tell the court that she had intentions of renewing, but since he was not going to fix this, she just has to make up her mind.
It was a breach on his part.
Yes,
it was a breach on his part. So he should do whatever he wants, but she
go girl. Okay, I hope she would do that. All right, let's get another call. 081 081 8999 Hello.
Hello, good morning.
Good morning. Please turn off your radio.
Yeah, I'm Lovett from Maraba.
Lovett, please turn off your radio.
Yeah, I've done that.
Okay, we're listening.
Yeah, ma, I paid for a house, and the landlord said that the lady has not packed out yet, but that I would like the house, that I should pay for the house. So which I did. So till now, the lady have not packed out, and my money has not been refunded. So I don't know what to do.
And you don't even know if you will actually like the house because you've not seen it.
Yes.
Okay. That's our predicament.
Why would you? I don't know if she has signed the tenancy agreement.
Why would you want to give somebody money for something you haven't seen, and you don't even know if you like it, and then now the tenant is refusing to move out? Okay, what if the tenant refuses to move out and they go to court and it takes like another 6 months? If there's no agreement for refund of the money, her money has gone.
That's why we always insist on a tenancy agreement. Now, the tenancy relationship commences upon the signing of the tenancy agreement. Now, if I sign the tenancy agreement, if she had actually signed the tenancy agreement,
her rent has started counting from that day.
But if she had not, and she had advanced money, I don't know what kind of relationship is that. She's going to actually find it very, very difficult.
Wait, so if you sign your tenancy agreement, let's say 2 weeks after you moved in, it should start counting from the 2 weeks.
Okay, if you sign 2 weeks after you moved in, it starts counting from 2 weeks after you moved in.
It will just count from the day you moved in.
You signed the agreement, or the date that is stated
on the tenancy agreement.
Because the opening part of the tenancy agreement most of the time will tell you this agreement is made on so day. So it could be that the agreement was made on the 12th of June and I signed it on the 20th of June.
So
the tenancy relationship will commence from the 12th of June.
Okay, so but if it wasn't written that way and then you signed it, for instance, on the 12th, and then you had already moved in from the previous month, all of those few weeks perhaps will be cancelled.
It's out of it.
Okay, nice. So in this her situation, obviously she's paid, she hasn't seen it, she may like, she may not like even if the landlord or agent is my father, I don't think he would really know for sure a house that I would like.
Exactly. Yeah, exactly. So
I wonder how she would have just paid money like that.
Maybe she was desperate.
Exactly.
If I was desperate, I would still see the house.
Yes.
I was still see
I don't know what to say to her or how to advise.
So if she does not have any written agreement that, okay, I've given this money, all she needs at this point now perhaps should be a proof that she gave him some money,
which is a receipt.
There's an issuance of receipt,
yes.
Okay.
Which of course is her right.
Okay.
For every payment of rent, the law provides that
the landlord must issue receipt.
A receipt. Now, even where there's no express tenancy agreement, there's a receipt.
So that at least she can get her money back.
Of course she can. And she can actually enter into an agreement with the landlord to say that, okay,
whenever the tenant moves out, when I move in, that's when my rent will commence.
So
that makes sense.
Not, probably she just made a deposit for the rent.
Yeah, things happen. Okay, well, that's about what we have for you on Pro Bono Chambers today. Many thanks to Barrister Maureen Itoha and Barrister Peter Oche. Do you have anything you want to add to all that we said?
Like I said the last time, always insist on the tenancy agreement as a tenant. Always. And sit down to discuss the terms of
the document properly
agreement with the landlord. Because everything boils down to a tenancy agreement at the end of the day. And that's unfortunately, that's the major document that the court will look into in evidence to see if the tenancy actually had terminated or not. So try as much as you can. If you cannot, if you are not educated, if you are illiterate, engage services of any expert around you to say, okay, come, please help me peruse this document. What's the legal implication of this particular term, so in case there's a default. So it's very important every tenant insists on the tenancy agreement.
All right. Thank you once again, and thanks to those who called in and those who just listened in. My name is Ruth Usman. Stay with us on Human Rights Radio 101.1 FM.
One radio.
Welcome on board to the Human Rights Radio.
Redefining broadcasting.